Hi, my name is Michael Burgis, and I'm the managing attorney of MB&A. I wanted to take a few minutes to discuss some recent case law. In this case, it is Reyes versus Northridge. This is a California Workers Compensation case, and the quick factual pattern of this is essentially there's an injured worker who needed home health care, and it looks very clearly like the defendant was not conducting a good faith investigation and not actively providing this care. The ruling is a case that it cites to both the labor code and some case law that I routinely cite, and I want to go over this one for the viewers. First, Labor Code 4600 and Rule and Regulation 10109. This Labor Code 4600 codifies the defendant, the workers' comp carrier's statutory and legal obligation to provide medical treatment and other benefits. And Rule and Reg 10109 codifies their legal obligation. And essentially what that is the defendants have a legal obligation to conduct a good faith investigation to determine what, if any, benefits are needed, and then actively and accurately provide those benefits. Now, what I know and what most injured workers in the community know is that the insurance company doesn't do any of this stuff. They sit back and passively do nothing and hope that, it saves them money. Ultimately, this case, and the exact ruling is, defendants have a regulatory duty to conduct a reasonable and good faith investigation to determine whether benefits are due. And the factual background on this case, essentially, the Workers' Comp Appeal Board explained an applicant, while employed as a truck driver on February 15, 2002, sustained an industrial injury to his back, neck, head, both legs, psych, and bilateral knees, and claimed injury to his neck, both legs, head, psych, chronic pain, liver, internal hypertension, and GERD. And essentially, sounds like a lot, but this applicant was in really bad shape, and the applicant was contending that they were permanently and totally disabled. Now, it looks like there was a treating pain management doctor, Dr. Miller, who opined that this person was 100% disabled and unable to compete in the open labor market and in need of home health care services. Now, it looks like there was an agreed orthopedist, Dr. Browerman, who deferred that opinion to Dr. Miller and then ultimately incorporated his findings. So essentially, you have a workers' comp doctor saying this person needs home care. You have the agreed medical examiner. That's the doctor that both parties agreed on, reviewing and incorporating and agreeing with that finding. And it was on this record, it appears, that the defendant had notice of a request for home health care, and essentially looks like they didn't do anything. At least they didn't actively provide that care. And ultimately, this case cites to a seminal case called Braywood versus WCAB. It's one of the oldest cases that's still routinely cited. It's a Supreme Court case, 1983. But that case, the holding was more than a passive willingness is needed to retain medical control, which means that the insurance companies aren't actively doing what they need to do to investigate and provide benefits. If there's a denial of care, ultimately an injured worker can potentially get permission to treat outside the network or assume medical control. So ultimately, this is a very, very good case. This is one of the many cases to recently come out regarding a defendant's legal obligation to conduct a good faith investigation and timely provide benefits. Frankly speaking, I rarely see insurance companies do the right thing. And I mean rarely. I can count on one hand, and having litigated thousands of cases, how many times an insurance company went out of their way to conduct a good faith investigation and timely provide, particularly home health care benefits. Home health care benefits are generally very much litigated because the carrier simply doesn't do what's right. And it's really good that we finally got a case out here that's really upholding and reiterating the defendant's obligation under Labor Code 4600 and Rule and Reg 10109. And this case, once again, Reyes versus Northridge, is in line with quite a few recent holdings that have come out of the Workers' Comp Appeal Board, specifically noting that home health care are legal benefits that an injured worker is entitled to if it's reasonably medically necessary. And there's a handful of cases that are coming out, once again reiterating and telling the defendant and these work comp insurance carriers that, look, you have a statutory and legal obligation to conduct a good faith investigation. And if a defendant and a work comp insurer does not provide this, this is where you need an attorney. This is where an attorney, an aggressive trial attorney such as myself, can turn around and file an expedited hearing or file for a mandatory settlement conference and set the matter for trial and essentially argue that the defendant's inaction or their passive willingness is not enough, and that because there's a denial of care, the Workers' Comp Appeal Board has potential jurisdiction to hear this issue and can find that the defendant loses medical control and potentially has jurisdiction to address whether home care is quote-unquote reasonably medically necessary. Now, I'm one of the few attorneys that routinely do this and litigate this. Very, very complex, but this case, Reyes versus Northridge, is a great tool to cite on a trial brief, and really it's going to give authority to the judge to determine that they do have jurisdiction, the defendant does have a legal obligation, and ultimately the court can address that denial of care, and a injured worker can seek justice at the Workers' Comp Appeal Board with adequate representation. If you have any questions or concerns about Reyes versus Northridge, or once again, Labor Code 4600, or the defendant's legal obligation to conduct a good faith investigation under Rule and Reg 10109, please feel free to give us a call. My office is here and we have the answers.